When we talk about representasi or representation, it means facts, points of law, narratives, arguments put forward in a letter by the defense counsel representing a person under investigation or an accused person that's sent to the authorities. In the situation of a pre-charge representasi, it is sent to the authorities or even to the public prosecutor, whereas for the bulk of representasi, as understood in our practice in Malaysia, it is sent to the public prosecutor after charges have been filed. It may be more advisedly before the trial has commenced, or it can even be done during the course of the trial, once or even multiple times. Sometimes even done after the trial has been completed at the stage of appeal. We're mainly concerned here of pre-charge representasi, and I'd like to discuss just my view how this is a waste of time. In the stage of investigation, it is the investigator who's the boss. Their job is to consider the report lodged by the complainant, who may be an individual, a company, a victim. It can even be done by an enforcement agency themselves upon receiving information. The investigation shall consider whether the outline of an offence or some offences had been made out, and then to proceed to gather witnesses, record their statements in statements, and to gather supporting documents in support of the narrative that was begun by the complainant. So from this, we can see how in our system of criminal justice, it's first past the post. Whomever makes the report first, they gain the advantage of covering as much territory as possible and influencing and establishing the narrative in the mind and in the bureaucracy of the investigation, compared to the other party who, late to the investigation scene, on the receiving end of accusations, will then have to play defense, has to be reactionary. By then, the initiative is lost. Therefore, reconsider an approach to be conservative, to not react, to make a preemptive report. Reconsider, because the costs of being on the defensive, on the back foot from then on, may be a heavy price to pay for the person accused. Why I say that it's a waste of time to put forward a representasi before charge is because of the role of the defense narrative in the Malaysian criminal justice system. At the stage of investigation, it's not like the investigator visits the public prosecutor and says, well, guess what, Tuan? This is what the complainant said, this is all the evidence, and guess what? The suspect says something different. It's not. If at all, it would be the opposite, that the accused confess, or the accused supports, or the accused points to facts which is supported by the complainant's narrative. So what role do you see from the perspective of the person under investigation? The role of the defense narrative at that stage is really very much just validation. It's just validation. Does it support? Does it corroborate? Does it shoot himself in the foot? Do they confess? Not much more than that. The role is more important indeed at the prosecution stage as that of trial, where certain information that is placed by the defense, especially through a statement, but not exclusively the witness statement of the accused, can benefit the defense tactically through what is often referred as an Alcantara notice, but more classically of putting forward the defense narrative that meets point by point, challenges and refutes and rebuts the points raised by the prosecution, evidentially, factually, and legally. So, although there is a greater role for a representasi, a lawyer's representasi at the trial stage, it doesn't mean you give it up. even though I do think it's largely a waste of time. It's just that you got to manage your expectation. Either yourself, if you're the person under investigation, or your clients, if you're the lawyer advising them. From the point of view of a prosecutor, how do you handle lawyers' letters when the case hasn't even been concluded yet? I have no idea. Please consult your seniors and superiors. I mean, what weight do you assign? Because the person, the suspect, the defense, they are disadvantaged because they can at best only guess what the case really is about. I mean, at that stage, it's still nebulous, embryonic. Even the prosecution might still be trying to formulate the right and most suitable case. Ini, the defense has preemptively put forward a representation. How are you going to make sense of that? There's not much weight that can be given, is there? And how would you brief your boss? So it's quite elementary that the investigation as well as the prosecution have statutorily prescribed rules, and from there I can't see a clear position on a lawyer's representation at the stage of investigation. So what does that mean? Again, the question, do you give it up entirely? No. There could be big cases, protracted investigation, complex, involving multiple parties, or where there could be, or where there are controversial witnesses, or where the case relies on some very contentious aspects in which the accused can help tilt the balance in the prosecution favor, perhaps as offering themselves as a witness. There could be some situations like that, but I think by and large it's not effective. So that is my take on it, and I hope persons who are under investigation continue to vindicate your rights and do not give up, because there is a system in place. Notwithstanding that the investigator is the boss at the stage of investigation, the decision doesn't lay with them. They only present the case, but it is the prosecutor who will make the final say. Good evening.